All right, welcome to module number 7. And in this module, we're going to be talking about money laundering statutes. Now, remember, I laugh cynically because, you know, I've been in business for 30 years as an adult in various forms, and I never ever thought the day would come where me as a law-abiding citizen and a business owner would ever be would ever be under the jurisdiction of the Financial Crimes Enforcement Network, which deals with money laundering, right? It's kind of bizarre, but that's where we're going to be as of January 1st, 2024. So we need to be aware. Okay. So always keep in mind as we're talking about the Corporate Transparency Act that it always circles back to money laundering, because as I said in previous modules, in my opinion, they think that we are money launderers, or the vast majority of us. Otherwise, why would they go after us so hard? Okay, so it's an increased risk, and we need to know what these statutes are and what the risks are. So, for example, just going to throw some examples out here. The 18 U.S. Code of 1956 criminalizes financial transactions that satisfy the conventional understanding of money laundering, namely transactions intended to conceal or disguise the nature, the location, the source, the ownership, or the control of the proceeds of specified unlawful activity. I want to emphasize conceal the ownership. Okay, that's what they're going after with all this reporting, the beneficial ownership info. And this is why we need to keep this in mind when we're talking about reporting and we're talking about errors. Okay, because this is specifically tied to money laundering statute. That's why the civil and especially the criminal punishments, consequences are very dire. And there's so much greater of a risk now to come upon this, because they can consider that to be, concealment or disclose the nature, even though it could be perfectly innocent. They're the judge and the jury. We're guilty until proven innocent. Okay, so that should put a chill up your spine right now. So it's all about the feds and their interpretation. Because of these money laundering statutes and the power that FinCEN has, they can freeze bank accounts and seize assets. There's a number of statutes here. I won't go into 553.17 or 1029 or 500 or 513. But basically what you understand is that funds from a bank account may be seized for forfeiture under federal law by federal agencies, which includes the Financial Crimes Enforcement Network. Okay, so we are, before you'd have to, if someone saw an odd or a suspicious transaction, the bank could do what they call a suspicious activity report, SAR. Well, and then they have to be an investigation started and so forth. Well, we're going to get into that in a later module, but they don't have to go through that hoop anymore with the Corporate Transparency Act. And, they can freeze your accounts for many reasons, but especially suspicious activity and suspected criminal activity. You may think I'm not a criminal, but they could think you are. Remember how we said willfully not complying? Keep that in mind the entire time. Okay. Or they can be, and they also have a thing called, it's going into assets, right? So if they feel like that you're willfully not complying, or they start an investigation and find something that they feel like could be considered, suspicious activity or having to do with money laundering or some other federal crime, which again may not be anything like that, but they start digging, they can justify pretty much anything. So they can consider your assets to be tainted, which means that they're in some way linked to the crime. They can be traced, or it was instrumental or ill-gotten gains. Okay, so you can just run your business, run your life, and all of a sudden, just like that, after some suspicious thing has been started, again by a bank, or let's say, you start an investigation started and they see something that they feel like is maybe it would be innocent, but in the context of money laundering, it can be considered, and they can use it as a hammer to go after you. So they can seize real and personal property under federal statutes 18 USC 982, criminal forfeiture, and so on and so forth. So this is no joke. And by the way, forfeiture means you're gone, it's over. And it doesn't have to be proven to be criminal for them to get started on. You don't have to be convicted. They can bring a forfeiture thing against a property if they feel like it was derived or used to commit an offense, rather than against a person who committed the offense. So what I'm saying is there's no criminal conviction that has to be required. Okay, now there'll still be some kind of court proceeding, and they have to prove something, but they're going to go through your stuff with a fine-tooth comb, and they'll use whatever they can to justify the forfeiture. And statistically speaking, only 1% of people ever get their money unfrozen or their assets returned. So that's why for those of you who say, well, I'm perfectly fine, I'm okay, it's not as easy as you think. And the point I'm trying to make here is that we're so much closer to them going DEFCON 1 from DEFCON 5 with this being under the Corporate Transparency Act than we were, before that happened. So the rules are changing, and if you think this is overkill, it's not. I just want you to be aware of this and how serious we're talking about. And oh, by the way, they can, if they want to, they can prosecute family members if they can, if they can say that, well, if they enjoy the ill-gotten gains of, house, cars, whatever, they can say, well, they're considered co-conspirators, and they can, go after them as well. So this is no joke. So I'll see you in the next module, and we'll keep going. Thanks.